Good day, everybody. Controversial adjustment of status and green card issues. When can you do interfiling? Can I quit my job the day after I get my green card? If I have two adjustment of status pending, is working on one EAD cause a problem for the other case? What about green card rescission? We've never talked about that. We will be discussing all of them in details. We'll give you the legal foundation for each opinion we give you when we come back. I'm Sam Shihab.
I'm Brian Burke.
We are from the law firm of Sam Shihab and Associates. And let's tackle the when can I quit my job after I get my green card first. Brian, can I quit my job the day after I get my green card?
Not a great idea.
Well, why?
Well, it's really a matter of what you promised when you went through with that green card application.
Promise who?
What do you promise to the government?
Okay.
Shall we look and see what you promised to the government?
Please show me.
Yes.
I'd like to see what I promised the government when I applied for my green card.
So let's check it out right here. There it is. So on your I-45 Supplement J, you have a certification that you complete, and it says the following. I further declare under penalty of perjury that I have reviewed the job offer described in Part 6, your green card job offer, and I intend to accept the position offered in Part 6 of this supplement.
So that is a declaration.
Yes.
Under the penalty of perjury.
Yes, saying what you intend to do.
Okay. So you intend to accept the position when the green card is approved.
Yep.
Okay. And I think we're going to get into what the penalty of perjury mean, what's a declaration mean, and then my question to you is, so the day after, so here I intend to, I'm looking at it here, accept the job at the green card approval, right?
Yep.
Now, what about the day after? And why is that not different?
Well, Sam, it goes to that question of intent. It is possible to have your intent change after your green card is approved. And we can probably each come up with some good scenarios where you might be able to change your job on day one after your green card, next day after your green card is approved. However, the question is, Sam, can you go into this green card application planning to change your job on right after you get your green card?
Right, you cannot.
You cannot.
So
it's about intent.
It's about intent, and the language, the word intent is in the declaration that people have signed under the penalty of perjury. So to make this clear, the intent is a state of mind, what you told the government you're planning on doing on the day the green card is approved. Mm-hmm. If you wake up next morning and then you change your intent, you're good.
Yeah, after you get your green card, your intent changes. Yeah. Yes, fine.
But if you had that intent before you got your green card, we got problems.
Correct.
Big problems.
Yeah. So is there a really blanket answer, Sam? Can you just flat out tell everybody, oh yeah, you can change your green card employer day after?
Absolutely not.
Yeah.
Absolutely not. As a matter of fact, I can, for every scenario, and we'll probably play out some scenarios here after we talk about what does these key words mean.
What happens if you don't do it right?
Yeah. For every scenario in which I can find a reason that you could quit your job after the green card is approved, I can find 50 scenarios that you cannot.
Yeah.
So really, these are very rare situations. These are not the norm.
Oh yeah, well, the hypotheticals I'm going to come up with just because I'm me are going to be wacky because they have to be kind of extreme. You know.
Yes. So let's break it down. Let's break down this sentence for everybody.
So here's the one we're referring to again. Oops, there we are.
And here in which, by the way, this is taking a part of the Supplement J that you have signed, and in which has the key word here we're looking at is declare. It's a declaration under the penalty of perjury, and then intend to accept the position offered upon approval of my I-485.
Yeah.
So we're going to talk about what does the declaration under the penalty of perjury mean, right?
Yeah, well, yeah, I have the really the federal perjury statute right here, the perjury law.
Okay. So a declaration, it does here, a declaration is an oath, a statement, etc., etc.
You're
right?
swearing. You're swearing, saying, I'm going to do what I say on this form.
Yeah, and this is what the statute that gives rise to the ability to say, I declare under the penalty of perjury.
This is perjury.
That's basically the federal statute that you're saying, I am...
Well, what's the penalty of perjury, Sam?
Yes.
Well, here it is. It's right there. You guys can already see it, highlighted in yellow. If you're
penalty of perjury, first of all, is an untrue. It's not the highlighted, but this is the consequence.
Yeah, this is the consequence.
The highlighted version is the penalty for violating the law.
Yeah.
But the perjury, under the penalty of perjury, meaning that your statement is untrue.
Yeah.
Okay.
Yeah.
And what's the penalty for that, Brian?
Well, you may be fined or imprisoned no more than 5 years, or both.
In jail.
Yeah.
So this is a criminal statute that you violate if you had a plan to leave the employer, right?
Mm-hmm. Yes.
To leave the employer before you got the green card, and you're just hanging in there to get that green card, and then you want to leave.
Yeah.
Now, so not everybody here is getting the wrong impression. Is this commonly prosecuted by the government?
No. Not at all. It's, I mean, no.
The government does not. We really have not seen that.
Yeah, this is not an area of focus right now, and sometimes the government just lets things slide. So I have no doubt there's plenty of people out there who know a friend of a friend who quit his green card job on day one, went and opened a restaurant or something, did something entirely different.
Or took a job somewhere else.
Took a job somewhere else, and nothing bad ever happened.
Right.
It wouldn't surprise me at all. Why? The governments, sometimes they're not the most organized, and sometimes they're not focusing in on issues.
And it's a priority. It's a kind of a more of a fashion. I think it's a priority thing. So the government has limited resources, and they decide to go after certain things. All of a sudden, one thing becomes a big deal.
I have a great example of that. So a couple, for H-1B cap counting purposes, if you want to be counted in the H-1B master's cap, you have to have a master's degree from a certain type of U.S. college or university. And for the longest time, people were filing just everybody with a master's degree in the master's cap, everybody with a U.S. college or from a degree from a U.S. college or university. And then 1 year, USCIS started going after those people and said, hey, turns out you don't meet the requirements, and they started clawing back people's H-1B cap counting over and over again. Nightmare.
And then that became a big deal.
Yeah.
After that, but for a decade, nobody looked at this.
Yeah. No, it wasn't a big deal until it was a big deal, and people got their lives screwed up over it.
Right.
So, not necessarily. We're not sitting here saying, "Oh, it's gonna come up and somebody's gonna get you," but it's not something you can just ignore.
You don't want to expose yourself to it.
Yeah.
Yes. Which leads us to the next important controversial issue that people don't talk about it, and we're going to spend a few minutes on it, is rescission of the green card. Can the government rescind my green card? Is there anything in the books that allow the government to rescind the green card?
Most certainly that there is. They have 5 years to do it, but they can also put you into deportation proceedings if they've gone beyond that window too. So
yes, so there is a rescission statute, and the standard for rescission is very low. Now, it doesn't mean that they can send you a letter say you lost your green card. It doesn't work that way. Not
for fun and entertainment. And they have rules they have to abide by.
And here's how it works, so I can lay it out for you, because there's a couple things you can learn from it. To obviously, again, rescission is not something that happens a lot, because USCIS prefer to send people to deportation rather than rescission or removal. They call it removal now. Mm-hmm. But here's how things work out normally. In the statute, it says that they will send the person in which they would like to rescind the adjustment approval, they will send him a notice. By
Yeah.
personal service, most of the time is by mail, which is allowed. They give you,
An explanation telling you why they think, basically the standard is, if they don't think they properly issued the green card, if they thought you weren't eligible, that's what they'll explain in this letter. And they say, tell us where we got it wrong, otherwise we're taking your green card.
and they give you 30 days to reply in writing why you don't believe they're correct, in which case they are now referred to a judge for a hearing, right? Now, when that happens, it goes to a judge for a hearing and you get your hearing. Oftentimes, you may not have updated your address through the AR11 process. And that's really critical that you should always do. File a Form AR11 whenever you move from one location to the other throughout your permanent residency life.
Yes, that's your good public service announcement. You're still required to file AR11 even when you become a permanent resident. You're only relieved of that obligation when you become a U.S. citizen.
Yes, and it is very critical you do that because the rescission letter will go to that address. They are not going to look you up on Google or LinkedIn and trying to find you. They're going to look up their file. They're going to say the last known address is this address, and they will mail that notice of rescission to the address on record. Why is this critical? It is critical because you are giving 30 days to respond. And if you do not respond within 30 days, what happens?
That's it. They revoke your green card and you actually don't have an appeal right associated with that.
You cannot even appeal it. The only thing you can do is challenge the
personal service, whether they actually did, give you notice of it.
Yeah, but and if they did give you notice and they did use the address on record, which is the wrong address, God forbid, you really don't have a recourse.
Well, at the very least, you have a really complex legal challenge on your hands.
Yes. So AR11 is very critical until you get your green card. Don't create an opportunity for rescission. A piece of statistic we were looking at the other day, since 2007, the government filed 288 denaturalization applications. That's when they took citizenship from people. 40% of them after 2018, during the Trump administration. During the Trump administration, all of a sudden, denaturalizing people became a big hobby, and they loved going after people and challenging it. So the government shifts focus from time to time, and you want to make sure that you're doing the right thing.
Are we on to the next topic, Sam? I think we are.
Moving on, yes.
I have a question for you, Sam. It's, can you submit a transfer on underlying basis in Interfiling to change your category of your I-45 from one to another when your priority date is not current?
Absolutely not.
Yes.
If the final action date is not current for your case, you should not file an interfiling, a transfer of underlying basis for your case from an EB2 to an EB3 or from an EB3 to EB2 because it is not timely filed. It's premature. And the complication is multiple because we do not receive receipt notice or acknowledgement from the government. The question becomes, do they acknowledge what category am I? Am I still in EB2?
In a weird, strange limbo. Sam, I have things to show people. I have some sources. So this is from the USCIS Policy Handbook, and here's what it says. When an applicant requests a transfer of the adjustment application from one basis to another, the priority date must be current for the category which the applicant wishes to use. So that's pretty much it. That's right from USCIS right there. That's how they judge these things. And I have another one, too. This is from the American Immigration Lawyers Association. What do they say? When an applicant requests a transfer of the I-45 from one basis to another, the priority date must be current for the category the applicant wishes to use under the final action dates chart. That's the final action dates chart, not the dates for filing and not anything else. Final action dates chart.
What complications would you have for prematurely filing a transfer underlying basis or interfiling with the government?
Well, the government doesn't really work that well, and here's a scenario we sort of talked about before this. It's you send in that premature request, and they do whatever they do with it, and you sit back and you think, I'm in a good spot, I've changed my basis, I'm changing over to the other category, it's just a matter of time. You might not have. You know, I don't trust the government to go ahead and pick up a poorly timed letter when your date becomes current. And then suddenly, you know, you're thinking you're moved over to the other category, and actually your green card case isn't moving. You're stuck in the EB3 category, which isn't going anywhere right now.
Which can take forever.
Yeah.
It can take years to find out.
Yeah.
So that you have this problem.
Yeah, and you sort of highlighted earlier is why people think they can do it is because the government doesn't tell you that they don't send a rejection notice, you know?
Yeah.
They don't send you anything. We've discussed this in the past on the transfer underlying, but there's no receipt notice, there's no check, so somebody can say, oh yes, definitely, you can do that, and you send it in, and the government won't tell you no, and you're inclined to believe them. And all you can really do is know that what the policy says. It says final action date must be current.
Let's move on.
Let's move on.
You have filed 2 adjustment of status, and you have 2 employment authorization documents.
Sure.
As a matter of fact, I want to even make it more interesting. Well, let's keep it simple. Because I'm guilty.
Making it more interesting is usually my department, Sam.
I'm guilty of making things more complicated. So you have 2 adjustment status pending. You have 2 employment authorization documents, one from the EB2 adjustment status and one from the EB3 adjustment status. Can you work on the EB2 adjustment of status EAD without affecting the EB3 adjustment status? And the other question is, can you work on the EB3 adjustment of status EAD without affecting the EB2 adjustment of status?
The answer is yes.
The answer is yes.
Yeah, you can use both of those.
Interchangeably.
Yeah, people ask, am I tied to one of these adjustment of statuses as soon as I use that EAD? And the answer is no.
You're not, there's nothing in the law that says you're tied to it. As a matter of fact, your right to use that EAD flows from a regulation. I don't know if we have it.
Oh, we have it.
That we can put it on the screen.
I'm maybe going to put it on the screen for you, Sam.
All right, perfect. It's the employment regulations. You may engage only in such employment as authorized by the government. A non-immigrant who is permitted to engage in employment may only engage in employment as authorized by the government. If you have a work authorization document, you can use that work authorization document.
Yeah.
Very simple. And therefore, working with one adjustment of status EAD absolutely does not negatively impact another adjustment status.
Yeah, when you say negatively impact, that's kind of what I latch upon. You know, it's have you done anything to hurt or harm one of your green card cases? And the answer is no. You've engaged in authorized employment. You can't hurt yourself through authorized employment in the United States.
Yes. I mean, what are the requirements for adjustment? There's a long list of them, but when it comes to employment, that you have not engaged in unauthorized employment,
Yeah.
right? So there is, you have to have meet medical qualifications, you have to meet criminal background clearances, you have to not have violated your immigration status, and you have to have not engaged in unauthorized employment. Where's the unauthorized employment or the employment authorization comes from? It's from the statute 214(1)(e) that we just put on the screen, which says you got a work authorization document, you're allowed to use it within the restriction contained therein. And that's it.
Yeah.
Very simple.
Yeah.
We'll be back to answer your questions. All right.
Well, Sam, I think it's time for us to take some questions. Let's get on into it.
Yes.
So let's see what we got here. So, here's one from Centaur. It's per the November 2021 Annual Immigrant Visa Report, EB1 13K, EB2 39K, and EB3 67K are pending. Also heard that over 65K were processed in Q1 2022. shouldn't the dates move more aggressively based upon this data?
You would think so, but
yeah, I'm curious. I've been looking, Centaur. I've been looking pretty much, every other day to see if the fiscal year, the Q1 2022 data has been published. So that's good. And I mean, Sam, we did a presentation, what was it, 3-4 weeks ago, where we really looked into the data as to how they were processing these. 65K isn't bad for employment-based cases because. I think we saw the peak at Q4 of fiscal year 2021 was about 80-some thousand.
Yes.
And we saw it going up and up and up and up over the course of the fiscal year. And one of my worries was that, at the beginning of Q1 2022, everybody would get lazy again. They'd go back to that, they'd say, no, September's so far away, September 30th, the visas, no, that's... Apparently, 65K is less than what they did in Q4 2021, as I recall. However, not too shabby, But shouldn't the dates move more aggressively based upon this data, Sam?
Usually, the movement of the date and the processing are two different things. Don't confuse them.
Yes, I agree.
So the movement of the date is visa availability. When you approve so quickly, you may find movement back.
Yeah.
So
my take is every time one of these cases gets approved, that's a visa being used up. And we all know that the government is really bad at figuring out when their visas are used, And I'm worried that, when these numbers get chomped through, that's going to finally give notice to the poor folks of the Department of State and say, hey, like you said, maybe this needs to move back.
Right. Furthermore, it all depends also on how fast the embassies are moving with the family immigration, because obviously the overflow is something that's going to happen at the end of the fiscal year. The question, which we've concluded that is in the play always, is whether or not the government is able to crunch. Is there going to be wastage at the end of this year? And I think in these visa predictions, to avoid retrogressions, there is a built-in assumption that there is going to be a percentage of wastage to be done. So in support of his statement, it is possible, I'm giving you the counter argument here, that the dates can move forward because maybe there's going to be a lot less wastage and they can process more green cards.
Well, something that always sticks with me is that Charles Oppenheim, hope he's happy in his retirement, was always saying, they're going to move the visa bulletin to gauge availability. So my perception was they don't really know that how many cases are out there. They just don't have that kind of information, though they really should. And thereby well, no matter what, again, approval of cases shouldn't really impact that availability. Getting new cases should say, hey, let's slow it down. But approving cases shouldn't move it. Is what I
approval case should move it to the extent that wastage is not built into the equation.
Yeah.
So if there's wastage built into the equation, they're saying, hey, they're going to waste 60 or 70,000 green cards, so let's not move them too far forward because what's the point? It's going to retrogress. If wastage is built in and they're moving too fast, it may move aggressively. So that's the unknowns. Obviously, it's the making of the sausage.
Well, this goes to the bit that we are out of the business of predicting the visa bulletin, because as soon as we start saying something, that's when it makes a fool out of us, right?
Yeah, absolutely. Yeah. Well, it is what it is. We'll find out soon, right?
Yeah. So here's a question from Sarabi Verma. So priority date November 2012, EB2 I-140 approved in 2012, EB3 I-140 downgrade applied, I-140 only, no I-45. Interesting. Still pending. Same employer, all through. Is it okay to file I-45 under EB2 pending EB3 I-140? Interfiling needed. So it doesn't seem like an I-140 has been, an I-45 has been filed on your behalf. And basically, I think the question is, Sam, is it okay to file an I-45 under EB2 while the EB3 I-140 is pending? And my answer is sure.
So yeah, is it okay to file a 45 under EB2 while EB3 I-140 pending? There's no problem.
Yeah.
And interfiling is not in play.
No, interfiling only comes into play. Remember, interfiling is the transfer of your I-45 from one I-140 it's attached to, it's already filed based upon, to another one. If you haven't filed I-45 yet, you don't need an interfiling.
Yes.
And here's a bit of a follow-up from Sarabi. So generally speaking, are the following statements true? Standalone 45 filings getting processed faster than concurrent I-140 plus I-45 filings, and the NBC has been faster than the Texas Service Center and the Nebraska Service Center.
So we answer the second one first is easier. Well, I think the first one is straightforward. Is I-45 faster to process than I-140 plus I-45?
Yes.
Logically, by at least a minimum of 10 minutes to 3 or 4 months.
Yeah.
Yeah.
So
I mean, sure.
To give you an idea as to when I talked with people, people talk to me a lot, Sarabi, about what's stopping my green card from getting approved. And the thing that really comes to mind for me, and I usually tell them, it's either your priority date not being current or your I-140 not being approved. And what I can tell you is it is taking them a long time to approve I-140s without premium processing. And a lot of those people who filed their adjustments in October 2020, they filed I-140 downgrades, and they weren't accepting premium processing. Well, they don't accept premium processing for downgrades initially, which is something we've discussed in the past. Meaning there are people who filed their I-140s in October 2020, and there are tons of them still waiting for adjudication on those, and that means their I-45 is stuck up. So, but back in October 2020, I know there are people out there who we filed, people who are disappointed that, I don't want to be an EB3, but they found their priority date came up faster than ever expected, even faster than EB2, and they filed their I-45 with their approved EB3 I-140 when everybody else is downgrading, and a lot of those folks have green cards right now.
So number 2, NBC has faster than TCS and NCS. I think we've done the analysis last week, and we found that the Texas Service Center is not as bad as everybody thinks based on the workload that they have.
However, yes, they have a great big backlog. As I recall, they had a great big backlog coming into fiscal year 2021 when all the adjustments came in, and basically it's going to be a delay before you see results from them versus seeing them from Nebraska Service Center, National Benefit Center. Right. So NBC. Here's the thing I will say about which service center is faster. It's doesn't matter because you can't control which one your case is sent to. Anybody's not aware, if you go to file an I-485, it tells you where your case must be filed. You can't negotiate that out with them. And they're going to send it to wherever they deem fit, and you are stuck with whatever you get.
And honestly, when we did the analysis, there's some differences, but really it's not as glaring. There are a lot of complaints about the Texas Service Center, but they had substantially bigger workload. They have recently been processing cases on a faster per case approval, or by percentage of cases approved, not per case, but percentage of cases approved compared to their workload. Mm-hmm. They're reducing their workload faster than others. But obviously, if your case is stuck there, it's stuck there, and it's painful. It is what it is.
Well, it's. I don't. Who cares if they're going faster if they haven't gotten to your case yet?
Precisely. Yes.
Here's another question here from Uma Garish. Here are. If Meng Amendment is passed along with the main bill, that would be, I think it's the defense spending bill, on February 18th, will EB2 and EB3 retrogress. So. Well, my recollection of we haven't talked about the Meng Amendment for a while.
Well, I have flashback to what Charlie said, that it will have some serious impact. Remember that?
Yeah, he was visibly. I recall stopping the clip showing when he commented on it. He seemed to be vaguely aware that it was out there, and he was probably acutely aware that it was out there.
He said it will be extreme retrogression across all categories for every country. He said.
Yeah.
That's basically what he said, which is quite serious. What he said.
Yeah. He did
not only India and China, every country.
Yeah, he did not look happy about that, and fundamentally, I believe he likes it. He liked what he did, and he liked seeing people get green cards. As do we,
I don't think the Meng Amendment will pass with the main bill, because right now we're starting to feel the weight of the tight labor market in the U.S. If you read the Wall Street Journal, I read the Wall Street Journal. It is the
It's not about what you read, Sam. It's the fact that it's hitting. I mean, you're of course going to read about immigration stuff. It's in your head, but it's
I'm reading about labor market.
Yeah, when that news is hitting places where the regular people read. That's when my father-in-law hands me articles from the New York Times about issues like this. That's
the tight labor market. Yeah, the tight labor market is now the stock market is now at a pivoting point. Because there's a big question is whether or not the growth these companies have can be sustained, and people are starting to kind of hedge a little bit and pull their money back a little bit, which takes the market dive. When the market dives, it's a reflection of the whole economy. So right now, there's a big concern about the labor market, and I don't think they are going to tighten the employment-based immigration.
Question from Sweet Seller. What is the criteria for getting green card interviews? Who gets it and who does not? Is there some pattern? Ooh.
Well, of course there's a pattern.
Yeah.
But Brian, and the pattern is a moving target, by the way. What is a pattern 5 years ago is a different pattern than this year. And it's natural different because people tend to do the same thing in groups. So the government gets nervous about certain things.
I imagine there's a training seminar and somebody points to a bullet point and says, hey, this is something that you want to interview people about. And everybody runs back to their cases and starts doing it.
There's 100% a training seminar. Do you remember the training seminar that leaked on the H-1B denial? Do you recall that?
Yeah, I think I do.
Yeah, so there are internal training seminars that are not made public. And Brian, probably you're right there on when they come out with the list of
that's where trends come from. They see what the cool kids are doing in the office, and everybody goes and says, "I want to try that too."
Yes.
So who gets in and who does not? I mean, I can think of some classic triggers. A more serious a criminal matter. A DUI is enough to pull an interview from USCIS.
Is or is not?
Is
yes.
Yeah. Changes. Sometimes supplement J. There's a changing of employer. That has been a trigger for an interview. Inaccurate information on your I-45s, because one of the reasons they call you in for an interview is they want to, to clarify stuff. When you go to an interview, they go through everything in the form, and if they think something is inaccurate in your form, they're going to want to hear it from you personally. Maybe have a conversation about it.
Prior case denials. That questioned your status. Let's say you had a denial on an H-1B in which there was a confusion about your status. You overcame it, you filed a new H-1B, but that denial stays in the record and get flagged, and sometimes when they're doing the adjustment, they want to meet with you and go over it just to make sure they're right.
Yeah, I think one that'll be an interview trigger in the future is something we talked about last week. It's those U.S. government sting schools, the University of Northern New Jersey and the University of Farmington. I bet those folks are going to be called in for green card interviews to discuss that.
However, if they followed if the class action lawsuit that we discussed the settlement is certified, there could be some protection.
Well, some protection, but ultimately, if they find out that you engage in fraud, and they might have some stuff to talk to you about.
Yes.
In that case.
Recent marriage is a big one. They just want to make sure the marriage is bona fide.
Yeah.
And I think, in my opinion, accepting your old employer from 7-8 years ago, I-140, and filing that adjustment of status and continuing to not work for them until close to the adjustment approval is a trigger.
Yeah, that's something I have seen as a trigger as well. Well, what I also got to say, it is possible, as far as I can tell, to be called for an interview for no good reason whatsoever. Perhaps it's just quality control. I've had plenty of people say, I went for an interview, I was called for an interview, perfectly pleasant, normal interview, and that's sort of that. So
a lot of those, honestly, you could be right, but a lot of times they thought there was something, and then by the time the interview came around, there was nothing.
Yeah, I have dealt with a lot of interviews where an officer really thinks they have something, and then after an interview, it becomes really clear that they don't. And you're right. I guess I could see that scenario where I mean,
it fizzles. The crescendo just falls apart. And
the scenario I think of this one is sometimes I'd go to an interview and somebody is very confused by the concept of an IT consultant. Like, how can your employer be located in Indiana when you're here in Florida? And you explain that during the interview, and then everything eventually goes fine. I like to think that some of those interviews are caused by they call on somebody for an interview and then they talk to one of their colleagues and say, oh, that's a thing. And then there you go. Yeah.
So that's a good question.
Yeah. So
with 485J, what is the last step? Just a receipt, or is there a 485J approval? Is approval of the 485J different from the approval of the 485? It's an excellent question.
Yes. So there is an I-485J approval. I have seen I-485J approval notices. They typically come at the same time as the I-485 approval notices. So the answer is they are different. The I-485 approval is the one you want, and the Supplement J approval will usually come at about the same time.
And the 485J came about because of the new law that was introduced recently, which is to be able to move to a new employer. Then they've said, okay, we'll use it for other things, for all evidence of employment. And in the 485J is your statement, your declaration under oath that you will be accepting, you intend to accept the employment offer at the I-485 approval. And that's the one that really will trigger any action potentially if there is a breach of that intention. If that intention wasn't there and you quit your job the day after, and then there could be an investigation. Without jumping to the next question, we did not answer the question, what scenarios?
Oh, yeah.
What scenarios would you see quitting the day after the adjustment approval justified?
Okay, Sam, I'm going to give one of my wacky scenarios. It's you get to work on day one after your green card's approved, and it turns out your job description, they've changed your job entirely. You say, you're an accountant now, not a software developer. My favorite is, it turns out you're the janitor now. Extreme example, but illustrates the point. If something's changed, and you can't take the job anymore.
What would be the procedure? Would you bring that up to the company, or we just quit?
I say you got to bring it up with the company. I'd say because here's what we never talked about, Sam. It's what your intent. You know what your intent, and I trust that most people act with proper intent and they go in. But if this scenario happens, and you leave the job because the company screwed you over, the government can question you. 5 years, for the next 5 years, and consider rescinding your green card if it comes to their attention, and you want to be able to defend yourself in that scenario. So yeah, go to the company.
Let's assume that you were a software developer when that labor certification was filed. You became a senior software developer when the green card was approved. And the day after the green card was approved, they told you, we would like to bring you back to a software development. And you're upset that you were demoted, but you were paid the salary in the labor certification. Is that a good reason to quit?
It depends on what you signed. If you signed,
you're the day after you're working the labor certification job with the labor certification salary.
I'd say you have kind of a grounds to leave your job. You're not getting your offered employment per the terms of your I-140 and labor certification. Yeah.
But if you are, I said that you're receiving that.
If you're getting the terms of employment offered in your labor certification, you should be staying in your job.
You should be staying in your job. So another scenario that we were talking about before the presentation about what could happen that would cause somebody to quit the day after and be able to defend themselves.
This is a creative scenario. It's yours, Sam.
So the scenario that we were talking about, let's assume you had a severe sickness in your family. Your mom, God forbid, is very sick. She's in the hospital. The doctor says, we don't know whether she's going to survive for the next 2 weeks or not. You go to your boss and say, I got an emergency. I have to leave. My mom is in the hospital. And your boss says, no, you cannot. If you leave, you're fired. And you leave.
Yeah.
I think you're fine.
Yeah.
But that happened after, right? Mm-hmm. If that happened the day before, you may have a problem because you changed your intention.
Yeah.
Right? But you would need to consult with a lawyer, and the lawyer would say, write on the job that I have every intention of joining my job upon my return. I must leave within a week. I have an emergency. I'm sorry you don't want me to leave, but I'll report back to work when I come back, and I think you'll be fine.
Yeah, something I say every now and again in employment-based immigration is you're not a slave. You don't have to do whatever your employer tells you until the end of time, and there are limits to their powers.
Another scenario I think you're justified to quit the day after is if there's no pay.
Yeah. I mean, we talked about it. That was the one. You're not getting. We boil this all down into a nice version of if you're not getting what you're supposed to get upon permanent employment,
you quit.
Yeah.
Yeah. Right. Yeah. Employer is committing fraud.
Yeah.
You discover the employer is committing fraud.
That's an employer problem, not a you problem.
But it can affect if it's related to your job.
Yeah.
There is some misrepresentation. There is a copying of code that's unauthorized, that you're being asked to copy a code from a copyrighted material, and that's a federal offense, and you say, no, I'm not going to do it. I'm quitting. I can't do that. That's justified.
Yeah.
But these are unique scenarios, right?
Yeah.
The one that you cannot do is interview before, make the phone call, say, I think the green card is coming next week, interview, and then wait, and then the green card comes in, and then the moment the green card comes in the mail, you grab the other letter that you have typed the day before or a week before, and you hand it to your employer and you resign. And that's not permissible.
Yeah.
All right, sounds good. So I thought to go some of those scenarios will be helpful.
No, those are fun. Here's another question. So when priority date is current, biometric done, is it possible to get the green card in that fiscal year?
100%.
Certainly, yeah.
Yes, absolutely.
It's a matter of will the government get their act together and actually accomplish that?
Yes.
Yeah. So from Sweet Seller
is filing social security number for a dependent child done with 485 application, or should it be applied separately after EAD or green card application? That's an excellent question. I don't have the visibility on that question.
I can tell you my thoughts on the I-40. So it used to not be on the I-45 form.
They added that about a year ago or so?
Yes. Yeah, I think so. And now there's a question on the I-45 that says, "Hey, do you want a Social Security card?" And so you don't even need the EAD to get that Social Security card now. Sometimes you hit problems, though, with the USCIS, despite the forms being completed properly, somebody doesn't get the Social Security card, and you should be able to do it.
Apply yourself.
Yeah, apply yourself is a short answer. Yeah. There's Centauro with his thoughts in the Q1.
Hasn't been published, but I heard they did a report out of AILA last week. Well, I don't know how can they do a report if it's not published, but I'll be curious to see it. So I'll look for it, censure and share.
Yeah, I mean, I want to do a follow up to see how they are doing on the data for sure.
We're all curious. If I use my advanced parole to enter the United States, I have an unstamped H-1B. What happened to the H-1B visa? Can I reinstate the H-1B after reentry? Well, the H-1B visa remains valid, but it's not effective on you at the time you are in parole. All what you have to do is leave the country, get a stamp at the consulate, and then present the H-1B I-797 approval and enter with it, and then you will be on H-1B.
So I'm gonna state it a different way. So when you enter the United States using your advanced parole, you enter as a parolee. Can I reinstate the H-1B after reentry? Probably, if you're returning to the same employer with which you if you're in valid H-1B status when you left, and you're returning to that same employer, you may be able to reinstate your H-1B with a new H-1B filing.
Per a memo that's about 20 years old.
Yes. Keep it going, Sam.
All right. Does it matter if I use family-based EAD advanced parole for travel while employment I-45 is also pending? I have both family and employment-based I-45 pending. I received EAD advanced parole from family-based case. Okay, so let's break it up on the EAD and advanced parole, one piece at a time. On the employment authorization document, you can use any employment authorization document. There's no issues there. Mm-hmm. On the advanced parole, however, you're paroled pursuant to that adjustment. And we have had a discussion on that. There's really no clear answer I would use the advanced parole document that has the most stable foundation, because if that adjustment of status, God forbid, is denied, that parole is no longer effective. Whereas on EAD, you can easily jump to a different EAD, as we have discussed, because you don't have to leave the country and re-enter to jump on another EAD. But with the parole is what allows you to stay in the U.S. So for me, I would be nervous about that issue a little bit.
Yeah, I'm going to give my cheater answer and say, don't travel on either of those APs. Travel on a non-immigrant visa, such as like H-1B, because it's your safe place.
If he has the option.
If you have the option.
If he doesn't have the option, if the family base is solid, which is probably the most solid one, is a family base.
Your employer can decide they don't like you anymore. It's less likely for your relative to do that, unless you have a bad holiday.
Right, that can happen. All right.
So, from Sweet Seller, is fingerprint applied the very last status update you get before approving I-45, standalone medical file along with received date receipt, or do you get any other status updates? So, great question. Perhaps is my answer. I have this saying, don't really trust the online tracking from USCIS. It is not. It is often not accurate. Sometimes people, they'll have their case get stuck with, RFE issued and they respond to the RFE and the RFE is still issued, or interview was scheduled and then you went to the interview and the interview still says interview was scheduled. So yes, possibly, but you could find the occasional one we see a lot. It was address was updated relating to this case, and you might see other updates before you finally see an approval notice. So,
if we file for a dual adjustment status, does it reset the AC-21 clock? No, it does not reset the AC-21 clock. I also might want to add that you can file the second adjustment earlier than you can file the interfiling. The second adjustment is filed on the filing date.
The dates for filing, assuming they're still available, which they are for the month of February. Yeah.
So if they're available, yes. Whereas an interfiling must have a final action date current. Yeah. And there's no resetting of the clock on adjustment.
So keep on going here. So currently have EB3 AOS and been more than 180 days, and preparing to file EB2 AOS, which means dual adjustment of status. So that's sort of the follow-up. This AC-21 portability reset, and I think you answered it. I thought your question was pretty clear. Sam was able to answer it.
If my previous question was not clear, no, it was clear, thank you. And again, it does not reset by filing a second adjustment.
Well, here's the sister question to that answer you gave. After interfiling EB3 to EB2, do I need to stay with my current employer for 180 days?
Yes.
Yes. So the transfer on an underlying basis resets the 180-day AC-21 time frame. Yes. Here we are. From Ashok.
I have filed 485 a month ago, and today I received 485J. What's significant? What does this mean, or does it mean anything? So you must have filed an I-45 with Supplement J,
yeah,
and you received the Supplement J receipt notice. So they have acknowledged that. I'm assuming you probably should receive or have received also I-485 receipt notice.
Yeah, I'm going to explain what I-45J is. I mean, we were talking about it earlier. So, Ashok, I'm going to presume that your I-140 was filed and approved a long time ago, or at least was filed previously, and an I-140 was not filed with your I-45. So when you file an I-45 separately from an I-140, they're required to submit a form called I-45 Supplement J. And I-45 Supplement J is where your employer outlines the job that they're offering you per the I-140 petition. It basically, they sign off on it saying, we're still offering this job, and you signed off on it saying, yep, I'm still taking this job. So that receipt notice for Supplement J is just basically acknowledging that they got the case, and usually I find that there's a bit of a lag time between when they send the Supplement J notice versus all of the other notices for the case, being the I-45, the I-131, I-765, if you file those with it.
Because I don't think they do anything except filing an I-45 Supplement J. They just issue it.
Yeah.
There doesn't to be a whole lot of thinking going on. They just send it. Whereas with the adjustment status, it's a complicated
yeah.
document. There's filing fee, there's money, they have to cash it, check.
They have to do something with the I-45, I-131, I-765. I-45J,
Technically speaking, the 485J should not come in until the I-45 receipt notices come in and accepted, by the way.
Yeah.
If the 485 is not accepted, the I-45J is a waste.
Yeah. Another question here.
In regard to somebody's question on faster processing center, what is your analysis on NBC? Are you seeing considerable slowness there as well, though it was faster for most cases? Can you clarify? Brian, you did the analysis.
I'm afraid my brain on NBC does not give me much. As I recall, though, I don't think they gave much data on the National Benefits Center.
That's what you told me.
Yeah.
There was not much data there.
Yeah, I mean, there's an NBC case number, and there's where your case is actually at, and somebody out there like Centaur, who's clearly out there reviewing the data, they don't seem to. I don't recall them putting much information out there about anything on the NBC about employment-based or employment-based green cards.
Yeah, because when we were evaluating the other service center, we were looking at two numbers: workload and number of cases approved. So, like if Lincoln, Nebraska, for example, approved 100 cases, and they have 200 cases, that's 50%. If Texas approved, 120, and they have a lot bigger workload, that's a lower percentage. So we were looking at that from that standpoint.
Yeah. Gonna keep it on going here. So both EB2, EB3 approved from same employer. If I interfile and I change jobs within the 180-day clock reset, does anything happen to my EB3? Can I continue my EB3 I-45 with new employer by just I-45J?
So both EB2 and EB3, I'm assuming I-140s, approved for the same employer. Okay. Now I do not know what 485 filed where to answer the question. So that's going to be. So let's fill in the gap here and say let's say they filed back in October on EB3 I-45. Mm-hmm. Now can he interfile with the same employer within the 180-day clock? That's the same question we asked.
Yeah,
and that sounds like you're more comfortable with that.
I don't think I am comfortable with it, because ultimately, if somebody.
So ultimately, you're saying you cannot interfile within 180 days.
I'm gonna say, I'm gonna say if the answer's not clear, I'm gonna be conservative, because that's that.
What happened to my EB3? Nothing happened. Your EB3 is perfect condition. It's sitting there, and you can file an I-485. So he interfiled to EB2 from EB3, and now he's asking, can I continue my EB3 I-485 with the new employer by just I-45J? No. You can continue your EB3 if you interfile from EB3 to EB2, because the I-485 now has, in our assumption, has been connected to the EB2 I-140. Now you can file a new I-485 for the EB3 if you need to. So that's doing the best we can. Tell us a little bit more about where the I-485 filed with and where is it going in your next comment, and maybe we can do a better job.
Sam, I'm gonna say why.
Let's take the next one. Yeah.
Okay, why I don't like that scenario. If he says change jobs within the 180 day, again, changing jobs is when you sort of run afoul of the.
Sure. Right.
We'll get into a fight on this one later.
That's right. Also, in my interfile, I think it's continuation.
Yeah.
Also, does my interfile application get abandoned when I move within 180 days after interfiling? Can I use my EAD to move to new employer within 100 days and reset? Thank you so much for your service. You're more than welcome. I am not understanding your question. No. It'll be great if we get a little bit more clarification. Brian, can you read into anything?
Does my interfiling application get abandoned if I move on? Basically, it sounds like he's presuming within 180. Whether I'm not quite sure. I'd be assuming a lot, I think. Yeah. So gonna keep on going here. So got an EAD in August 2021, but had second fingerprints for AP priority date is August 2013. Applied in October 20. 45 days approved. Submitted medical exams in October 2021. Still not received I-131. What do I do?
That's crazy.
I have a question for you. Did you travel? If you traveled,
you came back on H-1B, for example, left on H-1B and came back on H-1B.
They might have killed your I-131 for.
Would you file a second I-131?
Good.
Yeah.
Yeah.
I'd file a second I-131 I mean,
it's weird. They typically
It's forever.
will approve. Well, not only that. I mean, they'll typically approve your I-765 and I-131 at the same time.
I'm assuming you're checking online. You're saying still pending.
Yeah.
Lost, probably. Most likely lost.
I believe that. I don't see anything here about an EAD. But if you do have an emergency need for an advanced parole, obviously
Emergency is a different ball of wax. You have to meet certain
Well,
standards. I would file a new I-131 or escalate that one to the ombudsman or do some kind of an inquiry.
yeah, service inquiry is a fair one to
Yeah.
do on that.
Yeah. Before we get too aggressive.
Yeah, so he's saying he's only an EB3 filer. And, all
All right.
right.
Okay.
Well, Sam, it's 6:59, and
We've managed to answer everybody's question today.
yeah.
That's awesome.
Whew.
Thank you guys for listening us to today. Hopefully the controversial adjustment of status was interesting, and hopefully we answered all your questions. And for those that we didn't answer, clearly come back and ask again next week with a little bit more succinct, and love to detail it for you. Have a great
everybody.
day.